Judgment in the matter of Hassam and another against Rabot and another.
I will invite Lord Burrows to explain the judgment. The appeals in these two test cases are concerned with the whiplash reforms made by Part 1 of the Civil Liability Act 2018. Although the sums at stake in these two cases are small, it's clear that many thousands of cases are potentially affected by this decision. In general terms, the 2018 Act and the Whiplash Injury Regulations 2021 made under it have significantly reduced the amount of damages payable for pain, suffering and loss of amenity, which I shall refer to as PSLA, in respect of whiplash injuries caused by another's negligent driving. The regulations lay down a tariff amount that is to be awarded for PSLA caused by a whiplash injury, which depends on the duration of that injury. That tariff amount is significantly lower than the damages that would have been awarded at common law for PSLA caused by the whiplash injury. The question raised by the two cases is this: what is the impact of the whiplash reform on damages for PSLA in respect of non-whiplash injuries suffered by the claimant in the same accident in which he or she suffers whiplash injury? More specifically, what is the position on concurrent, that is, overlapping PSLA caused by both a whiplash injury and a non-whiplash injury? The parties' submissions have focused on three possible approaches to this issue. The first approach, advocated by the defendants, who are the appellants in these appeals, is that one should first take the tariff amount laid down in the whiplash legislation. One should then add the amount of common law damages for PSLA for the non-whiplash injury, but only if the claimant establishes that the non-whiplash injury has caused non-concurrent, that is different, PSLA. This approach therefore envisages a build-up from the tariff amount and requires the claimant to identify with some precision any different PSLA caused by the non-whiplash injury. And this was the approach accepted by Sir Geoffrey Voss, Master of the Rolls, in his dissenting judgment in these two test cases in the Court of Appeal. The second approach is advocated as their primary case by the claimants and as their sole case by the interveners, who are the Association of Personal Injury Lawyers and the Motor Accident Solicitors Society. According to this approach, one should add together the tariff amount for the whiplash injury and the amount of common law damages for PSLA for the non-whiplash injury without any consideration of whether there should be a deduction to avoid double recovery for the same loss. The third approach, advocated by the claimants as their secondary case, is that one should first add together the tariff amount for the whiplash injury and the common law damages for PSLA for the non-whiplash injury. Then, one should stand back to consider whether to make a deduction to reflect any overlap between the two amounts, that is, where both amounts cover the same PSLA. Such an adding together, standing back, and deduction is in line with what has been the standard approach of common law to assessing damages for PSLA for multiple injuries, whether involving whiplash or not, as articulated by the Court of Appeal in Sadler against Filipiak in 2011, which I shall refer to as Sadler. This was the approach laid down in these two test cases by the majority of the Court of Appeal, Lady Justice Nicola Davis and Lord Justice Stuart Smith. It was also the approach basically adopted by District Judge Hennessy at first instance. In the first of the test cases, Rabot and Hassam, the claimant was a passenger in a car that was negligently hit from behind while stationary. The claimant suffered whiplash injuries to his neck and back, and also suffered non-whiplash injuries to his knees. District Judge Hennessy assessed the tariff amount for the whiplash injuries at £1,390 and the common law damages for PSLA for the knee injuries at £2,500. Adding those together produced an overall figure of £3,890. Then, applying what was basically the third approach, the district judge made a Sadler deduction to reflect the overlapping PSLA between the whiplash and the knee injuries, so that the overall award was reduced to £3,100. In the second of the test cases, the claimant was the driver of a car that was hit from behind while he was slowing down at a roundabout. He suffered whiplash injuries to his neck, upper and lower back, and non-whiplash injuries to his left elbow, chest, left knee, and hips. The district judge assessed the tariff amount for the whiplash injuries as £840 and the common law damages for PSLA for the non-whiplash injuries as £3,000. Adding those together produced an overall figure of £3,840. She then made a Sadler deduction to reflect the overlapping PSLA, so that the overall award was reduced to £2,800. The majority of the Court of Appeal upheld the award in Rabot, but it increased the award in the second case of Briggs from £2,800 to £3,500 on the basis that while the approach of the district judge had basically been correct, there was a caveat that the overall award could not be lower than the amount of damages that would have been awarded at common law for PSLA for the non-whiplash injuries alone. So here, the overall award could not be lower than £3,000, and the majority considered that the appropriate sum was £3,500. The defendants now appeal to the Supreme Court, arguing that the first approach, and not the third approach that I've outlined earlier, is correct. The claimant's cross-appeal primarily arguing that the second approach, not the third approach, is correct. The Supreme Court unanimously dismisses the appeal and the cross-appeal. The third approach is the correct approach. I give the judgment with which Lord Reed, Lord Lloyd-Jones, Lord Hamlin and Lady Rose agree. The question raised is one of statutory interpretation. An examination of the words used in the relevant legislation in the light of their context and the purpose of the provisions shows why the third approach is correct. As regards the words, Section 3, subsection 2 of the 2018 Act makes clear that the tariff amount is confined to damages for PSLA, quote, in respect of the whiplash injury or injuries. And Section 3, subsection 8, which is the only provision expressly mentioning damages for non-whiplash injuries, talks of an amount, quote, that reflects the combined effect, close quote, thereby indicating that the reform is in general not departing from the standard common law approach to assessing damages for multiple injuries, which is that laid down in Sadler. This is also supported by the purpose of the legislation. The explanatory material makes clear that the perceived mischief was to discourage false or exaggerated whiplash claims and to reduce the costs associated with whiplash claims, and hence to help reduce motor accident insurance premiums. By contrast, there's nothing at all to indicate that the purpose of the 2018 Act was to extend the lowering of PSLA damages beyond whiplash claims. Moreover, there are serious flaws with each of the other two approaches. The second approach, advocated by the claimants as their primary case and by the interveners, incorrectly ignores the problem of double recovery for the same PSLA by awarding the tariff amount for the whiplash injury plus full common law damages for the non-whiplash injury. The first approach, advocated by the defendants, would tend to increase costs, contrary to the purpose of the reforms, by requiring a precision in relation to PSLA that is not presently required. Moreover, it would produce the bizarre consequence that the claimant might end up with a lower amount of damages for PSLA in respect of both whiplash and non-whiplash injuries than would have been awarded for the non-whiplash injury alone. Similarly, in some cases, the claimant would be incentivised to ignore the whiplash injury and to bring a claim just for the non-whiplash injury, thereby avoiding the tariff amount. Indeed, one might end up with the scenario of the defendant seeking to prove that the claimant suffered a whiplash injury in an accident, you suffered a whiplash injury, while the claimant seeks to deny that that is so, I suffered no whiplash injury. It's well established that an interpretation of legislation that produces absurd consequences should be rejected unless no other interpretation is possible. The interpretation adopted in the third approach avoids such consequences. The judgment ends by setting out step by step how the correct third approach should be applied. The appeals of the defendants advocating the first approach are therefore dismissed, as are the cross appeals of the claimants advocating the second approach.
Thank you. The court is now adjourned.